Good afternoon, and welcome to Part B of the Davis-Bacon webinar for contracting officials. Before we get started, I just want to extend to all of you who have been experiencing difficulties with the streaming portion of the webinar our deepest apologies. We're working very hard to correct them, but I understand based on the comments that I've been reading on the internet and through the email that the quality of our webinar this morning was not at the level that we would find acceptable. This morning's webinar will be posted on our Recovery Act website by the end of the day. So for those of you who were not able to see it in a manner that was able to permit you to capture all the information we shared this morning, that feed will be up later on this afternoon. We'll give you a link before the end of this session so that you can plug in and watch that session over again. We pray that the session that you're watching now is of a better quality, and so we will proceed with the agenda for the second half of our presentation. This primarily starting with compliance principles. We'll also be talking about how to evaluate compliance of contractors, and then we'll finally end up with an exercise on reviewing a certified payroll record. So without further ado, let's proceed with today's Part B of our Davis-Bacon session. Davis-Bacon compliance principles, there's a number of topics and issues that we need to present to you and help you get a better understanding in order to effectively administer and enforce the Davis-Bacon contracts that are under your purview. And we're going to discuss the following 6 topics that you see on your screen: laborers and mechanics, site of the work, apprentices, trainees, and helpers, fringe benefits, federal contracts, the interaction between PCA and Davis-Bacon, and also how a contractor should properly compute overtime under QASA. So each of these topics has their own subject material, and we're going to move through them bullet by bullet. Myself and Rex Elliott will be doing this portion of the presentation. Let's talk about laborers and mechanics. We actually got a few questions in the morning session asking us to define laborers and mechanics, and here is your slide. Laborers and mechanics are workers whose duties are manual or physical in nature. They can include in the definition apprentices, trainees, and helpers. For QASA purposes, we talked earlier today about this classification also including guards and watchmen. What's not included in the definition of a laborer mechanic? Timekeepers, inspectors, architects, and engineers, as well as bona fide executive, administrative, and professional folks who meet the qualifications for exemption under 29 CFR 541. Those folks are not considered to be laborers and mechanics. Jade, we had a question at the end of the first session about whether working foremen are subject to the Davis-Bacon provisions. Working foremen are generally non-exempt, and they must be paid the Davis-Bacon wages for that period of time when they're doing physical or manual labor. So if you have a working foreman who's paid on an hourly basis or is simply not exempt from the 541 rules, and that individual may work 20 hours as a carpenter on a job site and 20 hours in the contractor's shed preparing paperwork, reviewing orders for the next week, that individual is entitled to the prevailing wage for the time spent, in our example, as a carpenter. The other time is not labor or mechanic duty, and therefore that's not Davis-Bacon compensable time. Let's talk about site of the work. Site of the work has a history with the Department of Labor and how we have defined site of work. And this is a statutory phrase. Davis-Bacon only applies to laborers and mechanics employed directly on the site of the work. And the question is always, how does the Department of Labor define site of the work? So let's take a minute to look at that. Site of the work does not include a contractor or subcontractor's home office, their branch locations, fabrication yards, any location or that has a continuance of operation that was not directly related to the Davis-Bacon project that they're working on, and without particular regard to the contractor's performance on that project. So even if the contractor's home office is very close to the site of the work, If that home office has been there for years and that's where the contractor has traditionally been his base of operations on contracts throughout the area, those workers employed at those locations are not covered by Davis-Bacon. On the other, is that all we have for site of work, Mr. Sims? Okay. There are instances, and I'll go off the slides here for a minute to explain that there are instances where a location that's adjacent or virtually adjacent to the site of the work can be considered as covered under Davis-Bacon. Classic example is if we have a construction of a building here in Washington, D.C., and we have a contractor who received permission from the District of Columbia to take over the one lane of traffic that's on a particular roadway, and they set up a cement mixing plant there. Of course, that location's not directly on the site of the work. The building is being built about 20 feet over where the footprint of the building is. However, we would consider that temporary facility that was set up specifically for the project, dedicated to that project, and for which it's not going to exist after the project is over, as being part of the site of the work, so that the workers at that location would also be entitled to prevailing wage pay. Let's take a look now at apprentices and trainees. Apprentices and trainees, we talked a little bit about this morning. Apprentices and trainees have to be individuals who are registered in a bona fide apprenticeship program, registered either with the Department of Labor or a state DOL agency that's been recognized by our Bureau of Apprentice and Training as an approved state apprenticeship agency. These individuals can also be employed 90 days before they are officially enrolled in the program. So again, you simply can't call someone an apprentice unless, one, the contractor has an approved program to provide apprenticeship training, and two, has individually registered that individual in the program and is paying the individual in accordance with the wage scale and the fringe benefits provided in the apprenticeship plan. Trainees are similar. Trainees also must be enrolled and participating in an approved program by our Department of Labor Employment and Training Administration. Again, these individuals have to be in a plan that's been approved by DOL and also individually registered. Note that sometimes you'll see the name trainee on a certified payroll, and sometimes that's a contractor who does not necessarily have an approved training program. They're merely indicating that this individual may not have all the skills necessary to perform at the journey level work. If there is no such approved program for that contractor, then that would be a misclassification. The contractor cannot call that individual as a trainee. If they're doing journey level work, that individual would be entitled to the prevailing wage at the classification of work he or she is performing. Again, we mentioned earlier when we reviewed wage determination that you will not see apprentices and trainees on the wage determination. They are typically associated with a craft, either an apprentice electrician, apprentice iron worker, and their wages and their fringe benefits are paid according to the wage determination and the comparison of that to their particular level of education while enrolled in the program. Sometimes the question comes up whether an apprentice is entitled to the full fringe benefits listed in the wage determination. Again, the importance of receiving the apprenticeship plan is shown here because it's the plan that's going to direct how the apprentice's fringe benefits should be paid. Some apprenticeship plans say that the apprentices are entitled to the full fringe benefits provided to the journey level position in the wage determination. Other apprenticeship plans state that apprentices are entitled to the same percentage of wages as they're paid at their particular level. So if they're at 60% of the journey level for wage purposes, they're entitled to 60% of the fringe benefit listed in the wage determination. Each plan will direct how the fringe benefits are paid to an apprentice or a trainee. There are some plans in which they are silent with respect to fringe benefits, where the plan fails to mention anything regarding how fringe benefits are to be paid to an enrolled apprentice or trainee. In those cases, our regulations require that the apprentice or trainee receive the full fringe benefit listed in the wage determination. In addition to the percentages of fringe benefits, the plan's also going to direct what ratio of apprentices to journey level can be employed on the Davis-Bacon project at a particular time. And the ratios can be 3 journey level to 1 apprentice, 1 to 1, 2 to 2, and whatever is established in the plan is what we abide by. And what we'll see when we get to the compliance section in reviewing the certified payroll, you'll see the importance of knowing the ratio requirements, because you can literally look at a certified payroll and to determine if a contractor has exceeded the number of apprentices that should have been permitted to be employed on the Davis-Bacon project. If an apprentice is employed in excess of the ratio requirement, that apprentice is due the full journey level rate for his or her work on when they were out of ratio. Helpers. Helpers only may be used on Davis-Bacon projects when they meet these specific requirements in our regulations. And in general, you will not see helpers listed in a wage determination, and in general, you will not have a conformance approved for a helper classification. So please review these requirements, and if you believe that there is an individual that meets these duties, you may ask for a conformance. But again, I want to focus on that a helper can't be someone who's simply enrolled in an informal training program, and also the duties and work that the helper performs has to be clearly and distinct from any other classification in the wage determination. Hence, if you had someone asking for a conformance for a carpenter helper, and the definition of what the helper was doing was that they assisted in sawing wood and nailing boards to the wall, that's work performed by the carpenter. And we would deny that conformance request because the work is already performed by a classification in the wage determination. Excellent. Is this me? Off to you, Rex.
Off to me.
I'm now going to turn it over to Rex Elliott from NASA, and we'll continue with our discussion on compliance principles.
Thank you, Tim. As we learned this morning, the reorganization effort of 1950 placed on individual agencies the requirement for compliance and, in some cases, enforcement of the Davis-Bacon Act. Now, in my talk, we're going to go into numbers. We're going to do some arithmetic, get into some actual ways that things work in practice for wages and benefits. First, let's start with some terminology, though. The term wages or prevailing wages has some components. Let's talk about what that means. There's the base hourly rate, or the direct labor rate, as you sometimes hear it referred to. It also includes contributions that the contractor makes irrevocably to a trustee or third party to a bona fide fringe benefit fund or program. So there's some key qualifiers there. It's got to be an irrevocable contribution to a plan, and usually this would be a like a retirement, or possibly usually be a retirement plan, or to a third party or trustee. So there's some key qualifiers there. It can also include, however, the rate of cost that the contractor reasonably anticipates in providing the bona fide fringe benefits, and there's some conditions that attach to that as well. Now, under the Davis-Bacon Act, fringe benefits are a component of prevailing wages. The wage determination obligation may be satisfied by a number of ways, and this is one case where Davis-Bacon is a lot simpler than the Service Contract Act. Both the base hourly rate and the fringe benefit can be satisfied by just paying cash to the employee. Or there could be contributions made to one of these bona fide plans, or any combination of the two. There's a lot of flexibility here. Fringe benefits must be paid weekly for all hours worked, and that's hours worked. When you get into Service Contract Act, sometimes there's distinctions between hours worked and hours paid. Well, again, on Davis-Bacon, it's simpler. It's just hours worked, must be paid weekly. consistent with the certified payroll. Cash wages paid in excess of the base hourly rate do count to offset or satisfy the fringe benefit obligation. That's not the case with the Service Contract Act. Okay, let's get into some numbers. And these numbers are rounded for simplicity purposes. Suppose the base hourly rate on a covered contract for a given position was $10 an hour, and the fringe benefit requirement on that wage determination was $1 an hour. So you have a total prevailing wage for that labor classification of $11 an hour. Contractor can achieve compliance by paying $11 in cash wages. It can be $10 in cash wages plus $1 in fringe benefits per hour, or it can do $9 in cash wages plus $2 for fringe benefits. There's that flexibility. These are the typical examples for fringe benefits. And remember, these are things that cannot be otherwise required by law. So Social Security matching, things that are required by law, by another law, do not count. But fringe benefits, say your employer has a life insurance program or health insurance, pension contributions, vacation holidays, and sick leave, those all count. And the example we talked about earlier was when Obamacare kicks in full, the requirement for health insurance is going to be increased for a lot of employers, and I believe that means that the Department of Labor will be making adjustments to the fringe benefit portion of the wage determinations. Somehow it'll have to be allowed for. Okay, let's talk about funding of the fringe benefit plans. Contractors can take credit without prior approval from DOL for the bona fide fringe benefit fund contributions made to third-party trustees or insurers. They have to be irrevocably paid, and payments have to be made no less often than quarterly. And they take credit for it on the weekly payroll contributions, but the actual payment to the third party has to happen at least quarterly. And the credit's got to apply to the individual workers. Sometimes under Service Contract Act, it applies to the average for all workers in a pool. On Davis-Bacon, everything is on the individual workers. What about unfunded fringe benefit plans, where basically the equity of the company is pledged against the declared fringe benefits that are put on the payrolls? Costs must be reasonably anticipated to provide for that particular bona fide fringe benefit. Must be pursuant to an enforceable commitment. Basically, the employer can't just say that this is going to happen. There has to be an obligation on the part of the employer. It has to be a financially a responsible plan. It has to be communicated in writing to the affected workers. Let's get into some more numbers. Suppose a particular wage determination required a prevailing wage of $14.50 an hour, composed of a $12 an hour base hourly rate plus $2.50 an hour in fringe benefits. Contractor could comply by giving $14.50 an hour in cash wages, or $12 an hour direct wages plus $2.50 an hour in bona fide fringe benefits, or $11 an hour plus in direct wages plus $3.50 an hour in bona fide fringe benefits. Now let's go into the Tim mentioned we were going to talk about overtime pay calculations under QASA, Contract Work Hours and Safety Standards Act. Suppose an employee works 44 hours in a given week. This employee is an electrician. And suppose that the wage determination said the base hourly rate is $12 an hour plus $2.50 an hour in fringe benefits. So we can go through the numbers here. We see 44 hours were worked that week, so there has to be at least $2.50 an hour paid to that employee for the fringe benefits. The 44 hours also gets straight time. That's the $12 an hour requirement. And the final piece is the overtime premium. Those 4 hours, the hours that are in excess of 40 in a given work week, have, under the QASA as well as the Fair Labor Standards Act, have to have a time and a half for that overtime. So this shows you the calculation for figuring out that half, or the overtime premium portion. And you do the math, it totals out to a grand total of $662 for that employee for that week. Now, what about overtime computation where the employee is working at two different rates? Say they're doing more than one classification. During the work week, the employee worked 20 hours as an electrician, and which had the same base hourly rate and fringe benefits, and also worked as a painter for 24 hours that week, which had different base hourly rate and different fringe benefit requirement. Here's how you figure that out. You take the 20 hours that the employee was working as an electrician and apply the straight time, the $12 an hour, and come up with $240 an hour due as an electrician. Then you figure out the straight time that was due to the employee as a painter, 24 hours at $10 an hour, and it all totals to $480. Then you divide that $480 per week divided by 44 hours per week, and you come up with $10.91 as the average wage for that week. And here's how you figure out the overtime. You take that $10.91 and multiply that by the half. Remember, you're trying to figure out the overtime premium, times the number of hours that were in excess of 40, or the 4 hours. Here's where you come up with the calculation for overtime premium, $21.82 for the overtime premium for that employee. Okay, let's talk about how sometimes there's interaction between different statutes on government contracts. In this particular example, the Walsh-Healy Public Contracts Act and the Davis-Bacon Act have some interaction. Walsh-Healy Public Contracts Act covered contracts where there's more than an incidental amount of construction work. Well, the Davis-Bacon Act does apply to the construction work, and that's construction, rehab, painting, sometimes it includes demolition as well, alterations and repair, painting and decorating. That's what's covered by Davis-Bacon Act, but there might be other pieces of work that are on that same contract that are covered by Walsh-Healy, where the prevailing wage is just the national minimum wage. The regulatory citation in the FAR is there in 22.402. And I believe, weren't you going to be presenting these?
Yeah, but you were doing so good, I just thought I'd let you.
Well, man's got to know his limitations. I jumped ahead. I think I'm going to let Tim come back to do what he was supposed to.
Thank you, Rex. This section that we're talking about, the interaction of the Service Contract Act, the Davis-Bacon, and the Walsh-Healy Public Contract Act, at least for my team here in Washington, this is one of the topic areas that we oftentimes get involved with contracting agency decisions. And unfortunately, these matters are typically ones that we are forced to address after contract award. And I will simply say that it's my experience that when we write to agencies with questions as to how they made a determination whether or not to include another labor provision in the contract, we typically find that the agencies haven't really done a lot of thought or referred to the FAR guidance before making that decision. And so for those of you that are federal contracting officials, because the Service Contract Act only applies to federal contracts, I ask that you pay particular attention to this, because this is an area that even when you're sure that you're doing the right thing, you can sometimes make some errors that unfortunately can come back to your agency as cost issues. So let's look at the first item that Rex has introduced for us, and this is the interaction between the PCA, which is the Supply Contract, Supplier Manufacturing Act, and the Davis-Bacon, which is for construction. So you can imagine that there are going to be instances where your agency is going to contract for a supply contract. For example, in this case, the supply of the security system for a building. Clearly, that's the biggest expense item, the purchasing of the security system. However, you're also going to include in that contract the requirement that the supplier perform the construction work necessary to install the system. And that would be an instance where if you see this type of activity in your requirements, the replacement of existing conduit, the laying of cable, tearing out, replacing of walls, putting in new switching systems, new switching closets, that's construction work as we define it. And if it's more than incidental to the overall supply contract, your agency should have included PCA for the supply work and Davis-Bacon for the actual installation work. Another example is for the supply and installation of modular furniture. Again, looking at the scope of work and the requirements for the construction work, that has to be measured against the overall supply contract to find out if that's more than incidental. And both the regulations at the Department of Labor at 29 CFR Part 5, you also have very good guidance in the FAR at 48 CFR 22402B. So I encourage you to read through those provisions, because that guidance will assist you in looking at the application of Davis-Bacon and supply contracts. Daniel, let's move on now to how the SCA interacts with Davis-Bacon. And one more slide for me, please. One more. Here's an example. The SCA does not apply to any contract principally for construction. If you recall, when we introduced the statutes earlier this morning, we said that SCA has a principal purpose test. Service contract principally for providing services. So you can have a big SCA contract with some Davis-Bacon work, but you can't have a big Davis-Bacon contract with a little SCA work, because the overall statutory definition under the service contract requires that its principal purpose be for services. Remember, too, that construction, as we defined it under the Davis-Bacon Act, includes construction, alteration, or repair, including painting and decorating. So let's look at some common issues where a contracting officer is oftentimes faced with the decision of whether a particular solicitation should be covered by the SCA or the Davis-Bacon. SCA contracts are typically for maintenance, for scheduled, regular, and reoccurring maintenance activities, routine, something that's done in a continued state of continuous utilization. Custodial services, routine HVAC filter changes and cleaning the systems, snow removal are all examples of SCA covered contracts. Let's look at some examples of when Davis-Bacon would apply to particular types of contracts. A one-time fix to something that's not functioning, the restoration, alteration, or replacement of fixed components. We recently replaced all of the air conditioning units here at the Department of Labor up on the roof. Required a big crane. Those chillers had to be removed and new ones put in. That's not a service activity. That was a Davis-Bacon activity, because it required not only the replacement of the chillers, but also alteration to our existing cooling system so that it was compatible with the new machinery that we put up on the roof. So here are some examples. Here are some examples: building and structural repair, renovation, roof shingling, paving repairs are all Davis-Bacon covered activities. Here are some important considerations when you're trying to evaluate whether something should be Davis-Bacon or SCA. Davis-Bacon, when the activity is part of a construction contract, requirements before the public work or public building is accepted by the owners, and these examples are landscaping, cleanup, carpet laying, and drapery installation. All of these activities standing alone would be service contract. But if these are requirements that are folded in to the complete renovation of the Department of Labor building, for example, they would be performed under the auspices of the Davis-Bacon Act. Again, we talked about routine maintenance and upkeep. Our carpets need badly replaced in our office, and if that was just done on a regular and routine basis, we would award that under a service contract and not Davis-Bacon. And again, janitorial, mowing grass, replacing draperies that are worn are also SCA covered activities when not involved in an overall Davis-Bacon renovation project. Demolition work. We oftentimes get questions on demolition, whether it's SCA or Davis-Bacon, and the rules are fairly easy. It's SCA if there's no contemplation that new construction is going to take place at that site. So if we're demolishing a building here in Washington, D.C., the GSA is doing the demolition, and they have no plans to build anything at that site, they would award that under the SCA. If they were demolishing the building and had plans in place to award a contract for construction to build a new building in that location, then the Davis-Bacon Act would apply to that demolition work. And we have an all-agency memorandum, number 90, that gives you some further guidance on that. SCA contracts with Davis-Bacon segments. Remember, we covered this a little bit about SCA and Davis-Bacon. SCA principally has to be in play for it to apply, and then you can also have Davis-Bacon coverage activities where the work is physically and functionally separate and segregable from the other work called for in the contract and provides for a substantial amount of construction work. And please note, next slide for me, Danny. Substantial and segregable are defined. Substantial is the type and quantity of the construction work. Segregable is the work physically separate from the other activities required in the contract. One more. I want to get to the FAR clause for this. Can you do one more for me, Dan? There you go. This is an important FAR clause that I think provides excellent guidance to the agencies on when they should include Davis-Bacon and when it's SCA. So please make note of that FAR provision and look at the hours test that's involved, as well as if it's painting, the amount of square feet that are required for painting activities. Next slide. And here you can see the definition of painting. If it's more than 200 square feet, Davis-Bacon's going to apply to that work order or that task. If it's less than 200, just minor touch-up painting, then SCA is the applicable labor standards that should apply to that work. Again, in all cases, it's the contracting agency who has the primary and initial responsibility for determining the appropriate coverage when awarding these types of contracts. The Department of Labor has the final authority on coverage decisions on all contracts under the SCA, PCA, and Davis-Bacon. Whenever we do issue a final ruling, agencies do have the right to appeal those determinations to the Administrative Review Board, who acts as the final voice of the Secretary of Labor when it comes to prevailing wage decisions and rulings. Okay, deep breath. Jade Banks about to come up. She's going to do non-compliance monitoring. This is a workshop that we conduct at all of our prevailing wage conferences. Jade, the rooms are always packed when you do this, so I'm hopeful that the folks out there are able to pick up this stream, because I think they'll find this session very helpful. Jade Banks.
Thanks, Tim. Okay, so you've already learned everything you need to know about Davis-Bacon, the related acts, QASA, Copeland Act, all that stuff. You've got that down. We've covered that already. So we don't need to go into that anymore. What we're going to do now is build on that knowledge. For the purposes of this segment, we are going to assume that we have a project where we've established applicability. Our contract has the correct wage decision and the labor standards clauses in it. We verified the eligibility of the contractor and the payrolls are coming in, so what now? Well, we're going to talk about non-compliance monitoring. And I know that sounds odd, and I've taken some ribbing for it, but think of it this way. When you review payroll reports, who's looking for compliance? Anybody? I'm not. When I'm looking at payrolls, I'm looking for violations. And in particular, I'm looking for willful violations, because that's where the greatest damage is done. That's where the big money is. So before we move on, I want to make it clear that we know there are many, many compliant contractors. We know that. They do all the things they're supposed to do, and we're so grateful for it. But just like we don't review payrolls for compliance, we're not here to focus on compliant contractors. We're here to focus on the contractors that aren't. So payroll reviews. Who needs to review payrolls? Well, HUD does. You've heard many times about the reorganization plan number 14, making all the federal agencies responsible for their own administration and enforcement. So HUD has to review payrolls. We have a staff, a labor relations field staff, and they handle the payrolls for our multifamily development programs. As we've noted, HUD has thoughtfully delegated labor standards administration and enforcement activities to roughly 5,000 state and local agencies. So they need to review payrolls. Consultants need to review payrolls. Many of our agencies, especially the smaller ones, they hire consultants rather than developing in-house expertise. So they need to look at payroll reports. And lastly, contractors need to look at payrolls, in particular prime contractors, because the prime is responsible for the full compliance of itself, any subcontractors, and any lower tiers working on that project. Furthermore, the prime is liable for every single penny of wage restitution that might be found due to anyone working on that project. So primes, they get the payrolls before anybody else does. It's in their interest to take a look at those payrolls themselves. Now, in this session, we're going to talk about how to review payrolls efficiently and effectively. Pretty much what to look for and how to find it. So, we review payrolls went too far. We review payrolls mostly, basic stuff, to ensure that all the laborers and mechanics are paid no less than the prevailing wage based on the type of work they perform and the number of hours that they work, including any considerations for overtime. And remember, we're monitoring for violations, not for compliance. All right, there are two types of violations. There are face of the record violations, and there are concealed violations. Face of the records, those are the things that are right on the payroll report. The wage decision says you have to pay 20. The payroll says they're paying 15. $5 an hour is due. Everybody knows that. Face of the record violations are typically inadvertent. If you catch them early, they're not costly. And they're usually easy to correct. That's going to be handled somewhere else. We're going to look at the second set of violations, the concealed violations. And the reason that we're going to do that is because that's where the worst violations occur. An employer that knows what they're supposed to be doing, they know they're not doing it, and they're falsifying payrolls to conceal the violations, they're not going to go to all that trouble for small change. So we want to find out where the greatest violations are occurring, where the greatest detriment to employees is occurring. Now, as payroll reviewers, it's our job to detect falsification. When it comes to unraveling a falsification case, that's where DOL comes in. So you might say, okay, why DOL? Well, number one, DOL has resources. In the community where I am, the federal agencies and our state and local agencies, we have not really had a staff increase for maybe 16 years, give or take. So we don't have great resources. DOL does. You've heard probably already that DOL has really stepped up its enforcement activity and its enforcement capacity. So they have resources. Number two, DOL has trained investigators. They have people that do investigations for a living. We don't have that at HUD. That is not a primary piece of our work. It's a piece, but not a primary piece. So DOL has investigators that know how to put these things together. And third, DOL has a much broader scope of authority. As we've heard earlier today, at HUD, I can look at an employer and I may find out that that employer is underpaying on one of my projects. And then I might find out that that employer is on a Navy project. I can't really do much about it, except call the Navy and let them know. DOL can. They can cross agency lines. They don't have to worry about that. Even more than that, they can enforce other labor laws that we can't. If you think that an employer is underpaying their workers, falsifying payrolls, What are the chances there are other things going on that probably aren't okay? Probably pretty good. So it makes sense to turn these over to DOL because they can handle it all. On top of that, when payrolls are falsified, well, that means a willful violation. And willful violations can be a standard for debarment. On top of that, falsified payrolls can lead to criminal charges. So if our end goal, if our end zone essentially is debarment, then it only makes sense to give the ball to DOL right at the start. They know how to meet the standards for debarment. They know how to put the cases together. That's stuff that they already do, so that makes sense. And the gravy on all this, at least from my point of view, I've done a debarment recommendation, maybe once, twice. It's a lot of work. It is painstaking. It's miserable. Well, if we turn these cases over to DOL, we don't have to do the report. DOL does. Okay, so our job, oh, I'm sorry, and we've got something that DOL doesn't have. As payroll reviewers, all of us together collectively, we have access to every single Davis-Bacon payroll out there. DOL doesn't. So when we get them good leads, we can focus their resources where they can make the greatest difference too. So working together, feeding these great leads to DOL, we send a strong message that we and the Department of Labor are serious about Davis-Bacon compliance. Okay, compliance factors. Really, really simple, and it's a good thing because otherwise I wouldn't understand it. It comes down to 4 things: the type of work performed, the number of hours worked, the rate of pay for that work classification, and the actual delivery of wages to the employee. It's pretty straightforward. There aren't many twists and turns, so it should be fairly easy for any employer to understand what it is that they're supposed to do. So, moving on. We talked about limited resources. We cannot do it all. The days of 100% payroll review, they are over. Years and years ago, dinosaurs roamed the earth, Methuselah was around, I don't know if we had indoor plumbing, and I was working at the Columbus, Ohio HUD office. And my job was to review payrolls. And there were a lot of us in HUD that were doing that. And we were very earnest, and we were very thorough, and we were very busy. We date stamped every payroll when it came in. We dated and initialed every payroll when we reviewed it. We had logs that we kept very carefully with different colored dots that we would put there to show what violations we had found. Like I said, we were very busy and very earnest. I'm not sure how effective we were. Well, we don't have those luxuries anymore. We absolutely are going to miss some things. Okay, we know that. But what we can do is focus ourselves on the big things. So we're going to spot check payrolls. We need to prioritize and we need to focus. So by prioritizing, we focus on the major trades. And by spot checking, we look for patterns on payrolls, not little things. I mean, mistakes, they can happen. We're looking for patterns that repeat over time, that indicate a systemic problem. If everything's okay, we move on. If not, we get it fixed. Then we look below the surface. We want to see what else is going on there. So we see what's on the face of the record, right? Well, what's underneath that? Every payroll will tell a story, and we want to get a good one. So first things first. We want to be efficient. We want to be effective. The first thing we're going to do is sort the payrolls by employer and arrange them by date. And I know that can sound like a colossal waste of time. I assure you it's not. We're trying to figure out a story. We're trying to find patterns, and we won't be able to do that if things are all mixed up. When I was a kid, we had something, I think they were called flash books, and they were a bunch of pictures on a page, and as you fanned through the book, it would look like it was animation. Okay, so it told a little story. Well, what kind of story would you get if the pages were all mixed up? You're not going to get one. After that, we're going to check the signature. We want to make sure that the certification is valid, legitimate, and binding. So each signature must be original. It must be in ink, and it must be that of an owner, an officer of the firm, or someone authorized by an owner or officer of the firm to sign payroll reports. What it also means is that we do not accept Xerox copies. We do not accept PDFs. We do not accept fax copies. We do not accept pencil on payrolls. And no one other than the owner, an officer of the firm, or someone authorized by either of them may sign payrolls. So we make sure the certification is in order. Next thing we do is we make sure that the information is complete and legible. Does the payroll contain all of the information that you are supposed to get? Is it complete? Secondly, can you understand what's there? Because if you can't read what's on the payroll, you're not going to be able to assess that employer's compliance. So we want to make sure that we have information that's complete and that is legible and not in pencil. Because whatever is on that payroll, whatever the employer has attested to as being true and correct, must be indelible. We don't want any employer coming at us saying, oh, wait a minute, somebody erased this. I didn't put that down there. We want to make sure that that cannot come back on us. If these standards aren't met, we require resubmission. We never give a payroll back. Once it's submitted to us, it's ours. We want the complete story from the beginning to the very end, so we require resubmission. Now, we have complete, legible, and properly certified payrolls. So what? Well, we're going to do a real quick review here. We're just going to go down the face of the payroll, scroll down. Are the classifications on the wage decision, do we need a conformance? Did the employer classify correctly? Did they say journeyman or technician? Do we need clarification? Are the wage rates sufficient to meet the requirements of the wage decision? Are the hours correct? Did the employer compensate for all the hours, including overtime hours, correctly? If there are apprentices and trainees, do we have a copy of their registrations? Do the ratios look okay? Test them if you want to, but we don't want to spend a lot of time there. If we require corrections, we get them done. If we require restitution, that is going to be certified to on a corrected payroll report. We always want every single penny of earnings on that job, regular pay, restitution, overtime pay, for our laborers and mechanics must be on a payroll report somewhere. So we always want restitution on a corrected payroll. Back again with dinosaurs, Methuselah, and the indoor plumbing thing, and I was in Columbus, HUD used to require that the employers give us either a cashier or a certified check made payable to the employee or HUD. Then we got past that when we said, okay, just send a regular payroll check. And then we went to, oh, well, send me a copy of a check front and back, canceled check, that'll be okay. Or give me a receipt for the check. Well, for all of that effort and for all of our earnest approach, the best we could hope for, the best outcome is that we'd only manage to delay the delivery of restitution to the workers. So it doesn't work. Also, when you think about it, when you put all of that together, none of that, even combined, carries the weight of a certified payroll as far as evidence is concerned. So if we have an employer, we're requiring them to pay restitution, and they give us a certified payroll and they falsified that, well, that I think would be just about any DOL investigator's dream. The other thing to remember too is you can falsify stuff. You can falsify checks, you can falsify receipts, you can falsify all kinds of things. And if an employer does that for wage restitution, what's going to happen if we find out? They have to pay the restitution they were supposed to pay in the first place, right? Because falsifying a canceled check, that's not the same as falsifying a certified payroll report. Okay, so now we're going to take a closer look. The concealed violations. Here are some things that you can find on a payroll report that will involve falsification, misclassification of workers, reduction of hours, a deficient rate of pay, unauthorized deductions, and kickbacks. So the question is, what do these look like on a payroll report? What do they look like, and what are they trying to tell me? Luckily, we have some payroll falsification indicators. Because just like the compliance factors, real simple, 4 elements, Payrolls are exactly the same way. They're very simple. They're linear. They're not complicated. So when trying to conceal violations on a payroll report, it can get pretty frustrating. It's kind of hard to make a payroll look right when everything is but right. So we're looking for repeating patterns, anomalies and mistakes. They're going to happen, but we're not going to call out the brigade for those. We're going to get them fixed. We're looking for things that will show results on par with the investment of time that we're going to put into it and the investment we're asking DOL to put in should it go that far. One more thing to keep in mind. It's just as important to determine what is false as to determine what is true. Payrolls are very rarely falsified in their entirety. There's usually something there that you can rely on. So if you look at it like a puzzle, you want to take the falsified pieces out, but leave the correct pieces there so that you're filling in just what you need to. So figure out what is true, what you can rely on, and how that can help you with your case. Okay. First, falsification indicator, a ratio of laborers to mechanics greater than 1:1. And in this example, we've got 10 laborers and 2 electricians. So what's going on here? Most tradespeople, they carry their own tools, they carry their own supplies. So what is it that 2 electricians can be doing day after day, week after week, that could keep 10 laborers busy 8 hours a day? What could they possibly be doing? Well, what that's telling us is that we've got misclassification going on. Most likely, those laborers are doing some electrical work. Now, there are some exceptions. Some work requires more laborers, paving, landscape. At the beginning of a project, you may have more laborers, and at the end of the project, you may have them too. But that's not the norm. So, in this instance, what's false? The work classification. What's probably true? Everything else. The hours, the rate of pay, gross earnings, all of those are probably true. So what can you do to find out? Who can you talk to? Who has the answer to that? Well, the employees know something. So this is where on-site interviews can really be productive for us. All right, the next one, too few or irregular hours. Most people work a 40-hour week. If I could get away with maintaining my lifestyle and keeping my creditors happy, working part-time, I'd be on it. Anybody with me there? Okay, so most people work a full-time job if they can get a job at all. That's really the challenge now. It doesn't make sense. Crews normally work together. They don't work willy-nilly all over the place. So when you see payrolls where the hours are just spotty all over, somebody comes in here for a couple hours and somebody else comes in for a couple of hours, that doesn't make sense at all. How's the job getting done? You've got carpenters, followed by electricians and plumbers, followed by drywall hangers, followed by drywall finishers, followed by painters, followed by carpet layers. Well, that work isn't going to keep moving if for some reason the electricians just aren't there. They're not working on the job. So that's not how these things move. The last thing, most employers keep time by quarter hours, half hours, hour. That's the best that HUD even tries to do in an office setting. So on a job site, there's typically no time clock. So what in the heck does tenths and hundredths of hours, what is that doing on a payroll report? And what is 16.7 hours in real time? So let's take a look. What would these look like and what are they telling you? And there. Okay. Well, they're telling you that the employer is reducing the hours. They're backing into the hours in order to make it appear as though they've complied with the prevailing wage requirements. So you've got the earnings divided by the wage decision rate, that equals the false hours. So in this case, what's false? Obviously the hours and the rate of pay. What's true? Probably everything else. So let's take a look at an example. Here's an easy one. The wage decision requires $20 an hour. The employer is paying $10. So the employee, 40 hours times $10 an hour, earns $400 for the week. You take $400, divide it by the rate on the wage decision, and you get 20 hours. So the payroll is going to show you 20 hours times $20 an hour equals $400. That's how the employer can back in to the hours. Now, it isn't always that simple. So we have another example. The wage decision requires $33.68 an hour. The employer is paying $17.50. Well, 40 hours times $17.50 equals $700. In order to back into the hours, the employer is going to divide $700 by $33.68. And when they do, they're going to get 20.78, and then it goes on hours. And that's what's going to be showing up on the payroll. So that's how the employers can back into hours as well. Next, we have computation discrepancies. This is where the hours times the rate of pay does not equal the gross amount earned. So you've got round gross amount earnings coming out of uneven Davis-Bacon wage rates. Most Davis-Bacon wages need to, thank you. Most Davis-Bacon wage rates are in odd numbers. Employers often pay in even numbers, and so when they try to put those together, they end up with computation discrepancies. Thought I have an example. I'm going to move on. There's an example where, in the end, the employer's trying to make you believe, they don't want to mess with the gross wages, they're trying to make you believe that 20 hours times $33.68 equals $700. In fact, it does not. It equals $673.60. So how do you find out for sure? You go ask the employee. Extraordinary deductions, this is where you have people that are putting more into their savings account than they're taking home in their wallet every week. And that's telling you that the employer is taking a kickback from that employee. Compliance excess. This is when an employer starts sending you documents you didn't even ask for, like labor compliance agreements, where the employee says, my employer paid me everything I was supposed to get and they don't owe me any more money, thank you very much. We didn't ask for them. Maybe that employer is just trying to clarify things for you. Maybe that employer is trying to distract you with labor agreements and labor receipts from looking at the payroll reports and finding out what's really going wrong. I only have a few moments left, but I do want to touch on a couple of things. And these are underpayments that will never show up on the payroll report. They're not going to be there. The payrolls will be pristine, but there are still massive underpayments going on. First is where the employer pays in cash. Tim had an example today where the employer's writing checks. He drives everybody down to the bank. They cash their checks. They come out and they give the employer part back. Or the employer says, everybody come to the trailer, 5 o'clock Friday afternoon. I'll give you your pay. And the employer passes out envelopes with cash in them. Trouble is that what is in the envelope is not what the payroll says. And last, the employer can write checks, but then he'll just have the employees sign the checks back over to him and give them cash. Again, it's not enough. The last example, ghost employees. These are people that are not on the payroll, but they're on the project. They may be day laborers, they may be temporary workers. The employer probably has someone permanent working for them, and then they hire another crew, and they are not getting Davis-Bacon rates. On-site interviews can get you to those. It is now my pleasure to introduce Latricia Pratt and Calvin Cox, and they are going to go over a payroll exercise with you. Thank you.
Good afternoon. My name is Calvin Cox. Myself and Ms. Latricia Pratt will be giving this afternoon's session on the certified payroll exercise. This is meant to be a practical exercise on how to recognize some common mistakes that may be found when reviewing certified payrolls. Today, we will only cover a part of the full payroll exercise that is given during our regular prevailing wage conferences because of time constraints. You have access, though, to the full payroll exercise on our web link and access to the answers. The full exercise is 8 pages long and contains the instruction sheet along with a wage determination for the wage rates. Here's Ms. Pratt to kick off our presentation. I will follow her to walk you through the actual exercise.
Thank you, Calvin. Certified payroll records may contain the following information: the name, identification number for each worker along with his or her correct classification, hourly rates of wages paid, the daily and weekly number of hours worked, as well as the deduction made actual wage paid. Please note the following Social Security numbers and home addresses are no longer permissible on payroll records submitted to contracting agencies. However, identification numbers for each employee should be used. DOL has recommended contractors to use the last 4 digits of the employee's Social Security numbers. In this case, the prime contractor as well as the sub must maintain the full address and Social Security numbers for all workers as well as provide them upon request to the contracting agency and DOL. The contractor should submit weekly 1 single copy of certified payrolls within 7 calendar days after the payroll period. Additionally, the prime contractor is responsible for submission of payrolls by all subcontractors as well as, by all subcontractors once work begins. The required weekly payroll information may be submitted in any form desired. Also, payrolls submitted shall set out accurately and completely all of the information required to be maintained under the 29 CFR 5.5. Accompanied with the certified payroll must be a weekly statement of compliance signed by the contractor or subcontractor or the agent who pays or supervises the payments of laborers and mechanics under the contract. Payrolls and basic records relating thereto must be maintained by federal agency during the course of the project and preserved for a period of 3 years from the date completion of the contract. Agencies should produce them upon request of DOL during the 3 year at any time. Contract funds may be withheld if the contractor fails to submit copies of its or subcontractor's payroll in a timely manner. The contracting officer should withhold payroll of an amount that the contracting officer considered necessary to protect the interests of the government and the employees of the contractor or any subcontractor. Now I want to talk a little bit about how certified payroll should be handled under the Freedom of Information Act, otherwise known as the FOIA. Certified payroll reports are considered agency records as defined by Freedom of Information Act. Contractors' payroll records that are in the government possession must be carefully protected from any public disclosure. Payroll records may contain information in which employees have a privacy concern which the government may be required to protect. The FOIA explains the obligation on the part of the agency to respond to requests for records within 20 days of receipt and explains that the agency should advise the requesting party whether it comply with the request. On this slide, I'm going to briefly discuss electronic signatures and certified payroll submissions. Certified payrolls may be submitted electronically with proper use of electronic signatures. Also, electronic certified payroll can reduce processing and storage costs, as well as assist in compliance monitoring and expedite response to FOIA requests. Last but not least, submitting certified payrolls by use of a fax machine does not certify electronic signature requirements. And now I would like to turn it back over to Calvin.
Thank you, Latricia. What I'm going to do now is take you through the actual exercise. What we're going to start off is with a blank WH-347. This is an optional form. A little bit of information about the WH-347. The Copeland Act says work on fairly financed or assisted construction contracts should have a weekly statement as to the wages paid each employee during the preceding week. The Department of Labor regulations request contractors submit weekly a copy of all payments to the appropriate federal agency. The payroll should be accompanied by a signed statement of compliance indicating that the payrolls are correct and complete and that each laborer and mechanic has been paid not less than the proper Davis-Bacon prevailing wages for work performed during the week. The WH-347 is an optional form made available to the public. The only requirement that the Department of Labor has regarding the WH-347 is that all the fields listed on the form be reproduced for any other form that the contractor or agency chooses to use. For this exercise, we have completed a WH-347 and a statement of compliance. Your job will be to identify mistakes and potential problems with the WH-347 and statement of compliance. Again, we have made the full exercise and the answer sheet available to the public on our web link. As an overall framework for the exercise, please come to this exercise as if this is your first time reviewing a payroll for this particular project. You would note that this is the 20th submission for the project. You should take the view, though, that this is the first time you are reviewing this project's certified payroll. At this point, I will give you approximately 3 minutes to examine the first of 2 slides, the completed WH-347, and then I will give you a minute or 2 to review the statement of compliance. Please identify as many problems or potential problems as you can. Okay, this is a WH-347. The next slide shows a statement of compliance. And this is going to be the completed WH-347. And as I said, I'm going to give you approximately 3 minutes to take a look at this. The purpose is to find actual problems or potential problems on this. So my watch is ticking, and please get started. Okay, it's been approximately 3 minutes. What I'm going to do is go to the next slide on our exercise, which is a statement of compliance. I may flip back one quick moment before we go forward, but I'm moving right now to the next page 2 of our two-page exercise. This is a statement of compliance. As with the first page, please take a look and find any outstanding problems or potential problems here, and we'll move along in a minute or two. Thank you. Everything? Okay. Okay, ladies and gentlemen, what we're going to do is move forward. What we're looking at is on this particular exercise, what you should be noting on this slide, you see highlighted in blue 3 carpenters, Mr. Joseph Anderson, Thomas Betwell, and Todd Larson. To be noted here, as was previously mentioned, when you encounter a situation with apprentices, Mr. Tom O'Brien and Gordon Roberts, when you encounter this type of situation, you should be going to the apprenticeship agreement to see what's the proper link ratio between journeymen and apprentices. On this particular slide, what we're looking at is the apprentice carpenters and the trainee, Mr. Snyder. When you encounter this type of situation, what you should be looking for and going to, as was previously noted, is to take a look at their apprenticeship agreement. The apprenticeship agreement will give the proper ratio and give you information about if the person is in an approved apprenticeship program. If they're not in an approved apprenticeship program, as previously noted, these personnel should be paid at the journeyman rate. This next slide, what we're looking at is what you should be taking a look at is first the blue arrows. What the blue arrows is telling us is that the overtime. This is where on the certified payroll where you find out if anybody is earning overtime. The 3 carpenters, Mr. Joseph Anderson, Mr. Thomas Betwell, and Mr. Todd Larson are getting overtime on an hour each day. If you look at the other individuals on this 347, what you're finding is that they have 0 overtime. As previously mentioned, this is a little bit odd, especially for the apprentices. If you have a situation apprentices are working next to the journeyman, it's kind of uncommon or unusual for them to be not working the overtime hours also. So this is one of those situations that you probably want to talk to or interview the employees to kind of get a better picture of what's actually going on. In addition, you have the bricklayers. They're making 0 hours in regards to overtime, plus they're not even getting 8 hours during the workday. So this is one of those situations, as mentioned earlier, you will want to take a look at doing some interviews to find what is actually going on. As previously mentioned, when you're dealing with the WH-347 or a certified payroll, what you're going to be looking for is identification number. On the example that was given to you, there weren't any identification numbers provided. What we've done here is provide the individual's last 4 of the SSN, which is an acceptable format to be used. Okay, we're transitioning into the statement of work. One thing, if you remember from the earlier slide, the work one, we did not have the title for Mr. Hal Hardy, for Mr. Hal Hardy. Here, his title is President. As previously mentioned, what you want to have on a statement of compliance is an official of the company. If Mr. Hardy was actually an intern or secretary, that would not be acceptable. So what you're looking for is an official of the company to be on the actual statement of compliance. In addition, we have this other block here. The contractor should have selected one of 2 boxes in Section 4 as represented here. If the contractor is not paying all the fringe benefits to approved plans, funds, or programs, then box B should be checked as indicated here. Workers are being paid their fringe benefits in cash, and that's what this box indicated here is. What we're looking at this next slide is a signature block. For all what we've done in the submission of the statement of compliance, if this signature box is not signed, then that's not acceptable, and the contractor should, as indicated before, sign the signature block and do a resubmission to the prime contractor and or the contracting agency. What I'm going to do here is move on. We've covered a lot of information today. What I'm providing to you on this slide is wage determinations online. What I'm making note of to you is on the right-hand side, you see that little arrow, red arrow says library. Under this, if you click on that library, it'll take you this page here, which has a wealth of information available. So if you have future questions, please go to wdl.gov or wage determinations online, and you click on library, and you have a lot of more information available about the WH-347 Davis-Bacon in general. And this page here just has some information, some useful links that may be available or useful to the public. And lastly, this last slide is a reminder that for official guidance on the Davis-Bacon Act, please refer to the Federal Register, Code of Federal Regulations, or the FAR. And at this time, I'm going to turn you back over to Tim Helm. Thank you very much.
Thank you, Calvin and Latricia. And as a reminder, that full exercise is available on the live link. You can print that down. There are a number of other issues on those certified payrolls, so you can do that exercise at your own time. And we've also included the answer sheet for you so that you can verify that the selections that you made were consistent with the overall plan of the exercise. And as always, we remind folks that the certified payrolls are simply one piece of evidence that we use to determine compliance with the Davis-Bacon Act. We're winding down. We do have a few minutes for questions, so panelists, it's Stump the Panel time once again. Before we get to that, a couple housekeeping issues. We have been asked from some contracting officers whether we'll be issuing a certificate for this attendance at this conference, and the answer is yes, we can do that. So if you would like a certificate of participation, simply email us at whdpwc@dol.gov. We do have a requirement. You need a code word in order to get the certificate to show that you indeed have participated in the conference. So the code word for today's session is recovery. Recovery. Make sure you reference recovery in your email, and we'll get you a certificate in the next few weeks. Also, I'm very pleased to report that this morning's session was videotaped without error, and so we'll be posting that on our government contracts website later today. So for those of you who had some challenges watching the live stream this morning, that will be at dol.gov/WHD/recovery. So you'll be able to check in and participate in the morning session, and hopefully that downloaded stream will be a better quality for you. In addition, I know we've had some technical difficulties, but we do have a survey online at the link that you've used to access this webcast. Obviously, this is our first attempt at a webcast of this size, and we know we had some technical difficulties, but we very much would appreciate getting your responses as to the materials we presented, if they were adequate to your needs. Are there additional topics that you would like us to cover in the future? If you've attended any of our in-person prevailing wage conferences, have they been helpful to you? Should we continue to offer them next year? So I do invite you to go back to the live link and click on the survey and complete that for us. Your comments are always appreciated. Okay, here's some questions for you. See what we got. And I'll answer the first one, okay?
Fine by me.
Does the certified payroll have to be, does the payroll have to be weekly? We have some contractors that pay bi-weekly, and does that matter? And the answer to our writer is yes, it does matter. For Davis-Bacon Act, the laborers and mechanics must be paid on a weekly basis. If you pay bi-weekly or bi-monthly, you can continue that method for workers who are not participating on the Davis-Bacon project. But for Davis-Bacon workers, this does unfortunately require a change in your payroll methodology so that you are reporting and paying workers on a weekly basis. If you continue to pay your workers on a biweekly basis, you would in essence be falsifying every other certified payroll. So indeed, that is a requirement of the Davis-Bacon Act and the Copeland Act. So there we go. We had a question also about using the last 4 digits of the Social Security number as the employee identifier information on the certified payroll. Is that the only option? No. A contractor can come up with any employee identifier number if they have established payroll numbers for each of their workers. They can include that on the certified payroll and not just the last 4 digits of the Social Security number. Keep in mind always that the prime contractor should be collecting the Social Security numbers and addresses of all workers employed by all contractors and subcontractors, and that list should be available at all times for transmission to the Federal Contracting Officer or the Wage and Hour Division when requested. Okay, let's see if I can get you one here for our panel. All right, Ms. Banks.
Yes.
Who is responsible entity for maintaining original signed certified payroll records? The agency, on-site subrecipients who were awarded the contracts.
On-site subrecipients, I'm not real sure what that means, Tim. But I believe that the safest answer is that the original payrolls should be maintained by the agency. And for HUD's case, for example, the state and local agencies that administer our programs, that would be the agency that would keep the payroll reports. Subrecipients would not, I think.
And from the Department of Labor standpoint, for all certified payroll records, our labor standards provisions say that those records are indeed the property of the federal agency. So even in instances where HUD may have delegated that authority for the local contracting entity to hold the certified payrolls, or the Federal Highway Administration has given that authority to the state to maintain those certified payroll, we consider those federal records. And in the event that the federal agency receives a FOIA request for those records, they must get those records and respond to the FOIA. A response of those records are not under our control is contrary to the labor standards provisions that you placed in the contract.
Very good.
Okay. We had a question about, we had some examples, Rex, where a contractor who had a wage determination requirement of $20 and $5 an hour in cash wages and just decided to pay the employee $25 an hour. The question is whether the contractor is required to pay the worker at the $25 an hour rate when they work overtime.
Well, the short answer is no. But they do have to pay at the time and a half rate for whatever the number of overtime hours is. So you calculate it based on whatever the labor rate is, and that's what the overtime applies to.
And I always think using the example, Rex, helps folks out a little bit. So our example of $20 and the $5 in fringe benefit, the contractor pays $25 an hour in cash. The contractor in this case would pay $10 in overtime pay. That's the $20 rate plus the additional halftime. But remember, fringe benefits have to be paid for all hours worked. So the employee is entitled to that additional $5 fringe benefits, but not at the time and a half rate. Okay?
Right.
Very good.
The overtime premium of 50% applies to the base hourly rate.
Cool. Let's see what else we have. How are we doing on time? 2 minutes. I'll find one more question. Is there a timetable when Wage and Hour is going to stop doing investigations of the Recovery Act? What should the agencies expect? Well, I think we do know that although the Recovery Act is winding down, there are still a number of programs where Recovery Act funds are being used. Some of the Division B bond programs are continuing continue to exist and be awarded. And we're also aware that Energy has recently issued some loan guarantees under the Recovery Act. So certainly as we prepare for our next fiscal year, we'll be looking at additional directed work at Recovery Act programs, in addition to some of the project investigations that you have seen us complete over the last 2 years. This next year will be at the same level of enforcement that you have seen in the past few years here in the Wage and Hour Division. Danny, anything else? No, I think that's going to wrap it up. I do want to remind you about the survey online, and that we will have the Part A online for you later today so that you can watch that without interruption. And B, we'll probably see online tomorrow, guys. Maybe? Yeah, we'll see Part B, which you've just seen online tomorrow. So if you have coworkers that want to see that, both of them should be up and running. For those of you who are interested in the Service Contract Act, that show is tomorrow morning, same time, same place. Hopefully we'll have some of the wrinkles taken care of on our streaming issues, and Mr. William Brooks of my office will be leading that session on the Service Contract Act. Whether you registered or not, the link that you used today will work just fine for tomorrow. Again, thank you on behalf of my co-presenters, Jade, Rex, Latricia, Calvin. Thank you all for joining us today, and do not hesitate to contact us if you have questions in your important role in the administration of the Davis-Bacon Act. We appreciate it. Good night.